Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'm going to discuss my updated list of 10 provisions that should not be included in your will. Okay, so there are a number of important provisions that should be included in your last will and testament. Things like how your new will revokes prior wills, any specific assets you wish to leave to specific people, a residuary bequest, which covers all the assets not specifically bequeathed in your will, your executor or personal representative who will be in charge of guiding your heirs through the estate settlement process when you die, perhaps testamentary trust provisions to the extent you wish to leave an inheritance to someone in a trust as opposed to outright or in a lump sum, guardians for minor kids if you have minor kids, and there are likely to be a number of other standard or customary provisions in your will. But I've read lots of wills over the years, and sometimes I have to shake my head when I read certain will provisions because the will was just not the right place to state what was stated in the will. Here's 10 things that I've seen many times in wills that perhaps should not have been there. Number 1, your pull the plug decision. Many people don't want to be kept on artificial means of life support when it's determined that they are in a profound vegetative state with no chance of recovery. But your will or last will and testament is not the place to declare that. What confuses people is that the document often referred to where it is appropriate to state those life support machine desires is called a living will, which has the word will in it. Some people will tell me something like, I have a living will where I left my house to my daughter. But that's not right. I'll be the first to admit that this is confusing to people, but the bottom line is don't put your life support machine decisions in your last will and testament because your last will and testament may not even be looked at until days or weeks after you pass away. Document your decisions regarding artificial means of life support on, depending on your state, your living will or your advanced healthcare directive. Number 2. Jointly owned property or community property. Let's say you're married and during your marriage you bought a classic Ferrari. It's your pride and joy and you want to leave that Ferrari to your grandson. So in your mind, the most important provision in your will is that you left that Ferrari to your grandson. But when you die, everyone says, hold on now, Grandpa didn't own the Ferrari by himself. Sure, he treated it like it was all his, but he owned it with his wife. He bought it during the marriage, so his surviving wife owns half of it. You see, maybe his wife did not agree that the Ferrari worth hundreds of thousands of dollars should go just to her husband's grandson. So now we have a problem. The grandson will own half the Ferrari, and his grandmother, or maybe his step-grandmother, who thinks it's unfair that the grandson should be able to own that Ferrari to the exclusion of the rest of her family, owns the other half. Number 3, funeral arrangements. Like I said earlier, your last will and testament may not be read until days or even weeks after you pass away. By then, it's too late to honor your funeral wishes that you described in your will. Maybe in your will, you said you wanted a Star Wars-themed funeral with a Darth Vader funeral director. But if your family doesn't look at the will on the day you die and they instruct everyone to wear beach attire to your funeral, your wishes just won't be honored. So while it's not illegal to state your funeral instructions in your last will and testament, it's better to communicate and document those wishes elsewhere where they are more likely to be seen, understood, and honored. Number 4, assets in an LLC or corporation. Lots of people these days own rental properties inside of a limited liability company or LLC. Let's say you own an LLC that owns 4 rental properties. You put in your will that you want the property at 123 Sesame Street to go to your daughter. And 123 Sesame Street is one of the LLC properties. Well, you got a problem. You own an LLC that owns multiple properties. Sure, you can leave your ownership interest or membership interest in your LLC to others because that's what you own. But you can't bequeath specific assets inside of the LLC to specific people. So in this case, if you want to leave 123 Sesame Street to a specific person, you should put 123 Sesame Street into its own LLC and leave that entire LLC to whoever you want to inherit that property when you die. Number 5, assets in your revocable living trust. Many people create living trusts transfer assets to their living trust during their lifetime, and designate a trustee who will transfer trust assets to the trust beneficiaries when the person who set up the trust dies. The main reason people do this is that assets that are titled in your living trust when you die avoid the court and attorney involved probate process. But when you have a living trust and assets have been transferred to your trust, the trust instrument determines who gets those trust assets when you pass away. So if your $3 million brokerage account is titled in the name of your trust, such as John Doe as trustee of the John Doe Trust, and John's trust says that when John dies, the trust assets go to his 3 children equally, but John's will says that his brokerage account goes to his church, the church isn't going to get anything because the trust instrument controls where the trust assets go. John's will governs where assets that are titled in his name when he dies go. So if you have a living trust and you want to change who gets your stuff and you want to change who gets your stuff when you die, don't say I need to change my will. Say I need to amend or restate my trust. Number 6, scratch outs. This is one of my pet peeves. So many times in the past, I've taken a look at someone's will either during their lifetime or after they die. And obviously the person changed their mind about something after they made their will official because they took a pen or pencil, scratched through certain provisions, and in their own handwriting added a new name or provision, and then maybe they initialed that thinking that's what they need to do to make the change official. For example, maybe they struck through a bequest of $200,000 and wrote in the number $5,000. Or maybe they changed their mind about who the executor should be, so they scratched through the name typed on the document and hand wrote their new choice. All of that is a problem. For wills to be valid, you have to meet all of the formality requirements. And formality requirements exist when you wish to change one or more provisions of your will. Scratching through an existing will and penciling in something else, even if you put your initials by it, is not the way to do it. You either need to write a new will, which revokes the prior will, or you need to prepare a codicil, which is like an amendment to a will that meets your state's formality requirements for changing a will. Number 7, IRAs, 401ks, life insurance, and annuities. This one is pretty simple to understand, and it's pretty black and white. If you have IRAs, a 401k account, or if you own a life insurance policy on your life, or if you own an annuity, you should have been presented with paperwork issued by the financial institution when you open the account regarding who you'd like to designate as the beneficiary or beneficiaries of those accounts or that life insurance. It's well settled that if an IRA owner's beneficiary designation says that the IRA goes to person A, but the IRA owner's last will and testament says the account goes to person B, it's well settled that person A is going to inherit the IRA. Now, on rare occasions, we'll see someone designate their estate as the beneficiary, or perhaps if no beneficiary was designated, then according to the terms of the IRA contract or life insurance policy, it could be possible that the account goes to the estate. And if an account is payable to the account owner's estate, then the will does determine who inherits that. But again, it's rare that someone designates their estate as a beneficiary. It's much more common that people designate individuals as beneficiaries. Number 8, organ donation. Similar to your life support machine wishes and similar to funeral instructions, you shouldn't state your organ donation wishes in your will. For the same reason, your will may not be read until days or weeks after you die. And then it's too late, obviously, to donate your organs. Depending on your state, there's a proper way to document your organ donation wishes, whether it's completing something online, or perhaps it's through your Office of Motor Vehicles, or perhaps it's completing and signing a form by hand. But putting those instructions in your will, it's not the right way to do it. Number 9, personal items. Now, this one can go a couple of different ways, and I'm speaking generally here. First, I'll say if mom has a very valuable diamond ring and she absolutely wants that ring to go to her daughter and she's pretty sure she's not going to change her mind, then fine, mom can put that bequest in her will to make that bequest official. On the other hand, if mom has 3 kids that get along well and mom just has a bunch of stuff in her home, old furniture, worthless art on the wall, dishes, and other stuff, There may be no need to mention any of that in her will. Mom may be good having the typical provision in her will, I leave my estate to my 3 children equally, and then let the kids figure out how to handle that not too valuable stuff on their own when mom dies. And then another way to document wishes regarding personal items is formally or informally using a separate tangible personal property memorandum or simply a separate list of who you want to receive those items that have more sentimental value than fair market value. And if you do this informally, you'll hope that your heirs will honor your wishes regarding these non-titled personal items because you did at least in some form communicate your wishes to them. Number 10, leaving an asset to someone and directing they leave it to someone else. While you can use trusts and other vehicles to accomplish leaving an asset for the benefit of someone, and then when they die, someone else owns it, you can't leave an asset outright to someone and direct that they leave it to someone else. If you leave ownership of an asset to someone, they own it, and they can keep it, sell it, consume it, or leave it to whoever they want to when they die. So don't say in your will, I leave my house to Fred, and I direct that Fred must leave the house to Sally when Fred dies. So if you feel you need to get your estate legal affairs in order, you can click the link in the description below and request a no-expense Zoom estate planning design meeting with me where you'll explore what you want to accomplish from an estate planning perspective and figure out the most efficient way to accomplish it through my national estate planning law firm, America's Estate Planning Lawyers. Have a great rest of the day.